o'clock. We ready? Okay, so 1 o'clock, we'll go back on the record. Mr. Jorde?
Yes, thank you. And I do just want to make a clarification based on where we left off. What had occurred is that the South Dakota PUC staff filed a motion to deny Summit's application, and in North Dakota, the PSC had a work group meeting. So Mr. Jablinski is correct. I did not intend to cause Mr. Powell a heart attack. That wasn't my intent. So that I just wanted to clear that up for the record.
Appreciate you making the clarification.
Yes. All right, Mr. Rorie. I think, and if I could trouble the staff to pull that easement back up, please. Rorie, direct exhibit 1. I think where we left off, sir, was on landowner uses. That's paragraph 5. And is it correct that the landowner can use the property for all purposes not inconsistent with the purposes set forth within the easement agreement?
Not inconsistent, yes.
Okay. And then you go through in the easement a few sentences of explanation there, and then it goes down to, it says, and provided that such use does not in the company's sole discretion cause a safety hazard or unreasonably interfere with the company's rights under this agreement. So would you agree that's a way of saying that you, company, or whoever owns the easements can solely determine if a landowner's use interferes?
Yeah, it would be our discretion whether or not they've unreasonably interfered.
Okay. And then the last sentence, and if this isn't what you were referencing, tell me, but you see the last sentence where it talks about the use of the pipeline easement by landowners shall be regulated by all appropriate ordinances, regulations, resolutions, or laws of the governmental entity with authority over the pipeline easement. Is that what you were talking about earlier when you said that Iowa law would control?
Well, this is talking about use by the landowner. What I was talking about was use by the company. So I think there's a mention of Iowa law later in the miscellaneous section of the easement, but we'd have to get there and look at it.
Okay, all right. So this wasn't that provision that you were.
We were talking about it. I believe we were talking about abandonment in place or at will by the company, not by the landowner.
Okay, very good. So then if we go down to B, which on the top of the next page, please. It talks about that landowner may not use any part of the easement that may destroy or damage or injure or interfere with company's rights. Do you provide a list of those things, or essentially that general restriction?
A list of those things. Can you help me there? List of things the landowner could do?
Or can't do. Like essentially you are, just to let you know, farmer so-and-so, you're specifically prohibited from doing certain kind of things, or is it just a general prohibition?
There are some things listed there in that paragraph. Impounding water, drilling a well, constructing permanent structures, etc. So there's some things listed there, but that's not all. It's certainly the idea there is that we're asking for the landowner or paying for the rights to not have that easement obstructed or interfered with unreasonably.
Okay. And earlier in our discussion, you had mentioned that the way you look at it is you're basically buying the language and the relationship, I believe, is what you said.
That's a big part of it. Yeah.
Okay. And so therefore, is it your testimony that in some easements there might be language that you believe is more favorable to Summit, and therefore you might pay more, or if the landowner negotiates maybe more restrictions for them, there's a trade-off of paying less? Or help me with the buying the language. What were you getting at?
Well, buying the language, I wasn't really talking about devaluing as a result of restrictions in favor of the landowner, or I guess favor really wouldn't be the right word. What I was talking about is that's our commitment. I mean, I can say things, you can say things, but if you go away, it's their land, and it's their easement, and that language is binding. It's typically public, but it's certainly binding. And those are the commitments that both parties are making in that contract. So when I say buying the language, we don't typically, certainly on the right-of-way side, agree to anything that doesn't make its way into this document for that reason. So if there's special circumstances that we agree to in a negotiation with the landowner, we're going to document those so that our feet can be held to the fire on those, and that so that anyone in the future that owns that property can be reminded or have something to reference as it relates to the commitments that were made.
Okay.
So that's what I mean by buying the language.
Okay. And then subparagraph B there, it continues on and it has a list of some specific things that aren't allowed without written permission of company or summit. And obviously you don't allow temporary or permanent structures. Do you ever make exceptions, or is that pretty much something that you don't want to bend on?
Sometimes there are exceptions to temporary structures, not permanent.
Okay. And would that include, for instance, if it was a commercial property, you cannot pave over it, or could there be like a parking lot over the easement, or preferably not?
That's preferably not, but it's a case by case depending on what situation we're dealing with there.
And then subparagraph 2 talks about prohibiting the production or development of minerals. Does that mean, presuming, and there may not be, but presuming there's some minerals or some type of value subsurface, the landowner can't access the easement to get to those?
Well, what it says is they're prohibited from using the equipment utilized for the production of those minerals within the boundaries of the easement. They can drill and get to those minerals or however they need to get to them, but what we prefer or ask for in this easement is for no one to place a rig or a well or any of the operating equipment in order to extract those minerals within that narrow 50-foot strip and the workspace while it's in effect.
And the prohibition on that equipment is because why? The weight, the size, the activity, or?
Well, they're drilling into the ground. There's a pipeline down there.
Okay.
So we don't want them to hit it.
Okay, very good. And do you have any restrictions as to, quote unquote, normal farming activities that would be prohibited on or across the easement?
Normal farming activities, kind of broad, but we don't have any intent of restricting folks from being able to farm the ground.
Are you aware of the load analysis, if any, has been done as to the weight or the rate of a type of equipment that you authorize on top of the easement?
I'm not aware of a load analysis, as far as axle weights and things like that. And the reason I'm not is because these folks are operating heavy farm equipment on top of tile that is made of something very different, and it's typically much shallower than this pipeline is going to be. They go back and forth on that tile over and over and over again. There's also many other pipelines in the state of Iowa that have farm implements, farm equipment driving over them daily. So I don't spend a lot of time looking at the load analysis, given that we're typically going to be deeper than those older pipelines. We're steel instead of the material that's used for tile. And if they're not crushing their tiles, they're very unlikely they're going to crush our pipeline.
And in terms of tile, would you agree that tile isn't transporting a hazardous material?
Not that I'm aware of.
And if a farmer were to drive across an area where there's tile and crush their own tile, they're probably not going to sue themselves or face any personal liability for that, are they?
I don't know what they would do as far as to themselves, but it would certainly affect the way their ground drains, and they were crushing it on a regular basis due to the weight of their equipment. That would be a rampant problem across the state. There's a lot of tile here.
And is it true in Iowa you are committing to go 4 feet below the surface unless there's some type of extraordinary circumstances?
At least 4 feet. I think Mr. Powell touched on rock. We're not aware of any spots that I know of that we would need to go shallower, but 4 feet is a safe commitment there.
Okay. Can we pull up, please, exhibit landowner 558? and while we're doing that, we've looked at this before in North Dakota, but do you have any concerns about, as equipment gets larger and heavier, it seems like every year it's getting bigger and bigger, that instances like this where you can see the rear wheels there sunken down, and if a pipeline's only 4 inches, the kind of potential issues that might cause? Do you have those concerns?
If a pipeline's only 4 inches, what do you mean?
4 foot, 4 foot, pardon me.
I don't have any real concerns about that. I mean, in my career, I've managed the land side of thousands of miles of pipe when it comes to operational maintenance, lifetime of a pipeline type scenarios with all types of farm equipment. It's very rare that would happen, but in the event that it does happen, I'm not concerned that would crush the pipe or sever the pipe. I've never seen that happen, put it that way.
Right. And again, we're talking about forever easements and, things that might happen. Do you think, I asked you about your concern, but do you think it'd be reasonable for a landowner to be concerned about whether or not they can operate their heavy and large equipment back and forth across where a hazardous pipeline would be located?
I don't really discount landowners' concerns. So, I mean, I have to say, yes, it would be reasonable to be concerned about whatever they're concerned about. I think that we arm them with information about compaction, what our requirements are via this board, as far as reclamation of soil compaction or decompaction. The depth of the pipeline is another big concession on our part, juxtaposed with what the DOT requirements are for a pipeline to be depth-wise. So those conversations can happen pretty easily. Again, what I fall back on is there are quite a few pipelines. I can't tell you the number, but there's quite a few pipelines in Iowa that are much shallower than what we're planning to be. And this type of equipment drives over them all the time. I'm fairly confident that whether it's a combine or this tractor or something else, that if it's sunk down in the ground, it's very unlikely that it would break the pipeline, create a guillotine break or anything like that. I don't know. I see the width or the diameter of the wheel there. Don't know how deep that tire is, but the pipeline would be below that. I can tell you that.
Okay. So, I was looking at the ones in the back there. They're obviously, fairly sunken in there. But, in terms of the liability features and the indemnification provisions, would you agree that if a farmer or their tenant was utilizing farm equipment like this and damaged the pipeline to some degree, would you agree that you, Summit, would have the right to take legal action against them?
If they sunk their tractor on top of the pipeline because we didn't decompact the soil correctly or we did something wrong, or if they sunk it, period, and it wasn't a willful act to try to damage the pipeline, it wasn't something that would qualify as grossly negligent, then we have no reason to go after the landowner, or however you phrased it, I don't recall. But no, that's typical practice. They're driving over with their equipment, they're farming the ground. I see that as not grossly negligent and not a voluntary attack on the pipeline.
And of course, that may be your interpretation, but would you agree, unless that's spelled out, other future lawyers for Summit or other persons might not share your interpretation and could take legal action against a landowner?
I don't agree. I think that'd be really tough for them to do, considering at least the pipelines I've worked for, and again, thousands of miles of this all over farm ground. Never seen that action taken anywhere. So tough precedent.
Are you aware of the rights of insurance companies, for instance, whoever would insure Summit, that if your insurance company pays out a claim for damage, that your insurance company could actually go back against a landowner and try to collect from the landowner?
I'm not aware of that at all.
Have you ever heard of those type of cases, like subrogation interest? Are you familiar with anything like that?
No.
Okay. Can we pull up LO4, please? Oh, I should offer 558 before we forget.
Are there objections?
Yes, we'll object to foundation. I don't believe there was any foundation laid for what that picture is or who took it or where it was taken. Lack of foundation.
Okay. We will admit as Jorde landowner hearing exhibit 558 and give it the weight due.
All right, so then if we could move on to LO or landowner 4, please. I guess while we're waiting for that, sir, the next paragraph we have here is indemnification. And in a response to a previous answer regarding this type of scenario with the submerged tractor, tire, and wheel, you used the phrase willful, I don't know if you said intentional, but essentially a bad act, and then gross negligence. Do you remember that discussion?
Yes.
Okay. But in the indemnification provision that you have in the document we've been walking through, the proposed or the standard easement, you're aware that gross negligence or willful or intentional misconduct, none of those disclaimers appear in that paragraph, right?
Well, if you could pull it up for me, I could try to help you there. And I don't know if we're looking at the Exhibit C, which controls the document. There are a lot of our documents that have indemnification language that clarifies and uses the exact words I just mentioned. I don't know if this particular exhibit has that. But
Okay.
you'd have to look at Exhibit C to see the enhancement of the indemnity language.
Okay, and so just for staff's purposes, we can, look at paragraph 6, and then in the meantime, if you can still try to locate LO4, I'll go back to that. Let's see, paragraph 6. Okay, and again, I appreciate you wanting to go to the other exhibits, but this was the one attached to your testimony here, and so again, paragraph 6, indemnification of the exhibit that Summit attached to your testimony, there's no mention of gross negligence or willful conduct or intentional bad acts, right?
Well, I'm not our attorney, so I don't know if the noun acts there in Iowa encompasses only negligent or grossly negligent acts. I just couldn't tell you. I can tell you what the intent is, but I can't tell you whether that covers it. I'm simply not our lawyer. But what I'm talking about is not a different exhibit. I don't know if this exhibit includes what I'm referring to as an addendum to the easement called Exhibit C, which has controlling language. I just don't know if it's in there. If you could scroll down, you might be able to show me, but some of that indemnity language is enhanced, certainly something that we included in our easements as the project evolved to temper this concern.
Sure, and again, this is your exhibit that you have signed an affidavit on, and I'm walking through your attachment to your exhibit. And so sticking on, again, paragraph 6, indemnification, I don't think you answered the question, but it's pretty obvious from the text that nowhere do we see gross negligence, intentional act, or willful misconduct. We don't see any of those qualifiers in that paragraph.
I don't see those words. I just don't know if the word acts covers it. Again, not an attorney on this one.
All right. So let's just start at the kind of the beginning of that paragraph, the indemnification. It says that company agrees to indemnify and hold landowner harmless from and against any claim or liability or loss from personal injury or property damage resulting from or arising out of the use of the easement by company and then servants, agents, and invitees. Did I read that correctly?
Yes.
All right, so this is limited to acts that the company or those working on your behalf might take within the easements.
Within the easements, yes, that's the way I read it. But again, I don't know if it's a legal conclusion. You're venturing into one of the few things that right away does not talk much about in depth in terms of legal semantics. So you've done good at that. There's the insurance piece, the waivers of subrogation and things like that. We immediately get our attorneys involved to make sure we say things correctly there. And indemnification. So getting into the nuances of all the various types of indemnity really isn't my wheelhouse. But the way you just read that, it sounds like those are the words that are on the page.
Well, and I appreciate that disclaimer, but again, sir, for whatever reason, your counsel, your superiors have chosen you to be the person to talk about this. So it's important that we walk through it the best we can. As that paragraph goes on, on the right-hand side in line 3, it says, accepting, however, such claims, liability, or damages that may be due or caused by the acts of landowner or its servants, agents, or invitees. Did I read that correctly?
You did read that correctly, yes.
So this language, would you agree, is not covering, not indemnifying, not holding harmless for damages that may be due or caused by the acts of landowner or servants, agents, or invitees?
It depends on the definition of acts. I don't mean to be redundant here, but I don't know what that would encompass. I also need to point back to, this is our base generic easement. Our base generic easement also includes exhibits such as the legal description, the sketch, and what I keep referring to as Exhibit C. Exhibit C has additional language that typically cites indemnity. If that was not part of the exhibit, then that's a mistake on our part. Because Exhibit C would be part of every easement that we put in front of a landowner.
All right. Well, again, I'll submit to you that it's not part of the summit exhibit, and so I'm just walking through the evidence that you've brought here. So, and you've heard, no doubt, worries and concerns, you might have touched on it in your testimony, about landowners who have attempted to see if they could obtain coverage to get around pollution exclusions and to protect themselves in case there are claims in the future of damages or loss caused by carbon dioxide. Are you generally familiar with those concerns?
I'm familiar with the concerns, I've heard some accounts of landowners being concerned about that. I've not, in my experience, ever seen a landowner that couldn't get insurance on their farm as a result of the presence of a pipeline. We also have insurance. We've talked about that, I believe, some in these hearings. But we have insurance to cover those problems and those claims. Whether a landowner can obtain their own insurance is not really something I'm familiar with. All I can really say there is that there are a number of landowners, hundreds in Iowa, where we're not the only pipeline on their property. And there have been recent pipelines placed on their property. I've never heard of a landowner telling me or saying or currently not being covered from an insurance standpoint on their property. It's also sort of evidence that a lot of those landowners have executed easements with us, so they certainly didn't have any concern about insurance or being excluded insurance-wise as a result of a pipeline that was already there or our pipeline being placed there. So I have not looked into whether or not someone was able to get covered. It's really not my area of expertise, but
So,
I've never heard of a landowner not being able to get insured. That's not something I've seen.
okay. So I take it from that answer that it's your conclusion that if someone signs an easement, that they therefore must not have concerns about much of anything.
That's not accurate.
Okay, well, you just said that if they've signed the easement, they must not have been concerned about the insurance piece or lack thereof. That's what you just said.
If a landowner couldn't get insured because of our easement, then they would tell us that. And it's very unlikely that they would sign an easement and sign themselves into a situation where they wouldn't be able to be insured. That's unlikely. It's a valid concern for them to bring up and look into and explore for themselves. But my point is that this idea that's been disseminated widely, and we've been able to quell it quite a bit in certain states because insurance bureaus, et cetera, have stated their own opinions. But this idea that Summit Carbon Solutions is going to put a pipeline in and you won't be able to get insurance on your farm is a false idea. That's not real, and it's also been a hindrance in our conversations with landowners. So we have talked about that some with landowners that have brought it up. But to go back to your question, do I believe that someone signs an easement and therefore has no concerns about anything? No. What I do believe is if they execute an easement with us, then they've taken the time to talk to us and give us an opportunity to present facts and address those concerns and temper them so they can understand the full picture. So if we don't have a dialogue with them, there's no conversation happening, then those concerns tend to marinate and grow. So when it comes to insurance, I've just not heard of this in Iowa or Pennsylvania or southern Louisiana where a landowner or a farmer could not get insurance on their property because of the presence of a pipeline. So I don't believe that to be real.
Okay, let's break that down. So the phrase you used there is you don't believe that a landowner could get insurance. And I want to ask you this. Would you agree that the ability to call up State Farm or whomever and get a policy and pay them money has nothing to do with whether or not, if there's a claim, State Farm will pay out for a specific loss? Those are two different things.
Well, I would agree that it depends on coverage, right? What the customer selects. I mean, I don't really dive into landowner insurance declaration pages to know what all is covered there. I've just not had a landowner say, I can't get insurance because I signed an easement with you. That's my point.
Sure. And again, get insurance. Insurance companies will take your money. I mean, I'm sure you pay premiums. We all pay premiums. The question is, when you come with a claim, will you be covered? That's the concern. Not can I give money away to insurance company, but if there's a claim, do they go to the 60 pages of fine print exceptions, or are they going to cover me? You understand that's the concern.
Well, I suppose what I'm saying, get insurance, would be synonymous with be made whole.
Okay.
So that would constitute the actual payment of a claim. That's what I mean by that.
And have you had experience with what's known in the industry as the pollution exclusion and exceptions in insurance policies to not pay out claims if the damage or the proximate cause of the damage is a pollutant, i.e. carbon dioxide or a hazardous material?
No, I've seen some writers that showed things about pollution, but no, typically I don't.
I'm going to ask staff to try to pull up LO 12 if you can, please. Okay, so that's, oh no, sorry, yeah. Or that's fine, that's another way to get at it, sure, if we could minimize that a little bit. So, sir, you had, well, I don't want to put words in your mouth, but I thought you had said you hadn't heard of any reports or a landowner not being able to get coverage, strike that, not being able to have coverage for damages caused by carbon dioxide, that you weren't familiar with those type of letters?
I wasn't really talking about damage for carbon dioxide, or however you phrase that. What I was dispelling was the notion that a landowner couldn't get insurance or get claims paid on their property as a result of our pipeline being present. Again, our company has insurance policies. I am not the expert on our insurance policies. I know that they're confidential by nature in terms of their declarations, but I don't deal in that world to know exactly all the different tranches of insurance we're going to maintain. There perhaps someone else in our company that could talk about that, but I'm not the guy. What's been disseminated out there that I've seen be a little bit rampant in certain areas is that landowners could not get coverage on their property, period. Now, if you're talking about pollution, environmental, something tied to land, water, and air, whatever you've got here, I don't know what individual carriers are talking to whom about that. I don't concern myself too much with it because we're the ones carrying the insurance for things that we do and problems that we cause. And the indemnity language states that. So I mean, we have to cover those things. So that's the extent if I could talk about it today.
Well, but remember, your only liability is, per the easement paragraph 6 that we looked at, is for damages you cause within the easements. If the landowner farming, tractor sinks, causes damage, you're not covering that. That's not part of your indemnity language. Do you understand that?
Well, you're misrepresenting what I'm saying. Again, you're referring back to the exhibit that was filed. That's not the whole easement. The exhibit C that controls that easement has indemnity enhancements in it, typically. And if it didn't, we would always include that or always offer that. That would obviously and specifically exclude the idea of someone sinking their combine as being on the hook to pay for the damage to the pipeline. So I understand it's an exhibit. I understand you're referring to it, but it's not the whole story.
You were framing your prior answers related to, I guess, misinformation in your opinion that you couldn't get coverage due to the presence of the pipeline. But do you understand the purpose of my questions are, if something were to happen to the pipeline once it's there, such as the impact, such as an unintended release, I'm getting at the damages that occur after that. Do you understand?
Yes, and I am trying to wrap that in alignment with you of gross negligence and willful misconduct and purposeful voluntary things to damage the pipeline. Sure, we would not insure someone for that, but everything else we would.
Are you making that commitment on behalf of Summit here today?
From an indemnity standpoint, I believe I'm echoing what's already been said, that unless there was something grossly negligent that occurred, or there was willful misconduct on behalf of the landowner, their invitee, their guests, their tenant, whatever party is appropriate in the landowner site to be out there, if they cause damage to that pipeline purposefully, willfully, if they're under the definition of gross negligence, and however the semantics of that work in Iowa, if they damage something willfully and are grossly negligent, then that's not us. Everything else is. So normal life, normal farming practices, sinking a combine, ground got soft, dug in, caused a problem to the pipe, chisel plowing, running tile, whatever it is that will be normal for their farming practices, I believe that's already been covered by Mr. Powell, and my intent is to echo that.
Okay, but I want to be clear now. You said a lot there. Is that Micah Rorie's opinion, or you as an agent of Summit? Are you here today before this board able to bind Summit and make that commitment of what you just said?
Well, I don't have the authority to bind us. I am an employee of Summit. What I am saying is that that is certainly our intention, what we relay to landowners, and it translates into our easements. So the indemnity language, it's been quite exhausted throughout this process for the last couple of years. We haven't changed our stance on that in my mind. So you're asking me under oath what I think, and how to answer your question is that unless somebody does something harmful on purpose to damage our pipeline and interfere with it, which specifically contradicts the rights that we're purchasing and that we need to operate a pipeline safely, then that would be on them. And everything else is on us. I mean, if it's tied to our acts or tied to normal farming life, however you would define that, then I don't feel that we're going to be seeking anything from the landowner there.
And if what you just said isn't maybe totally clear in the easement or the Exhibit H attachment, are you able to agree here today that if this board were to approve this project, that they could take this transcript and make a condition, the last two answers you gave me, on how you believe the liability work shakes out?
I have no say or idea on what the board could and couldn't do, and I'm not familiar enough with the parameters or the rules of what's in their jurisdiction. I have seen other permitting bodies include indemnity language in the criteria of their permit. That is something that's happened before in South Dakota. Our indemnity language mimics that language almost exactly. I'm confident that that type of language that we're utilizing would apply in Iowa just the same. But again, I can't speak to what the board's going to implement there as far as the criteria.
All right, well, I think we've kind of covered indemnity, but I would offer Exhibit 12, LO 12.
Are there objections?
Is this what's on the screen? Sorry, I can't.
Is this what you are calling LO 12?
Well, I believe that's page 1. There should be hopefully some letters just like that deal with coverage. If we can maybe go down, I hope there's a couple more. Yeah, and yep, that's LO 12, correct.
Thank you for the clarification. Yes, we'd object to lack of foundation. There's been no testimony as to what exactly this is.
Hold on one second. Okay, Mr. Jorde, we're having some difficulties kind of understanding how you organized this. So just if we could get some clarification, what you refer to as LO 12, is it specific pages within this 356-page document?
Good question. So I thought my staff, they told me that they extracted from this document or those like it what is attachment 12 and separately made that its own discrete, 8-9 page exhibit that I refer to as LO 12. If that didn't get done, it will get done. But to directly answer your question, I'm only talking about those few pages, not the whole thing.
Okay, do we have that attachment 12? Okay. We do not appear to have attachment 12.
So I can get that.
Delineate the pages
Yeah.
in this document and use the pages, the 142 of 356. Let's use the document as we can see it here.
Okay, and my apologies, okay, so attachment 12, could you just type in page 1 just so we can reference which landowner's testimony this is, please? There, yeah, right there. Okay, Benita Schills. Okay, then if you could go back to that page we were at, please. All right, so Your Honor, I would offer, starting at page 137, and then if we could scroll all the way down, please. through, I believe, is that say 148?
146, I believe.
146, thank you. So 137 through 148, which is also known as Attachment 12 of the Bonita Shills pre-filed testimony, and I will separately upload it and Exhibit 12 so we don't have confusion in the
Okay,
future.
so that says 146, but you just said 148 again.
What, 146, thank you.
Thank you. Okay. The board will admit pages 137 through 146 of the Bonita Schultz filing as Jorde landowner hearing exhibit 550. What number? Yeah, Jorde landowner hearing exhibit 12.
I appreciate that, and sorry for the confusion.
All right, and we'll be given the weight too.
Thank you. All right, thank you for having that up there. We can move on. I want to get to paragraph 7 of back to that easement we were looking at earlier, please. That's the assignment provision, and quite basically, this simply allows Company Summit to sell, assign, transfer some of the rights of the easement, all of the rights of the easement as your company sees fit at any time to anyone, correct?
It's generic form of assignment, yes.
And along those lines, are you aware if whether or not the exit strategy on Summit Carbon Solutions is to sell the company prior to the 12-year expiration of the 45Q tax credits?
No, I have no idea.
No idea either way?
I've never said the words exit strategy in my employment at Summit.
But not something that's come up in a conversation with Mr. Powell or others?
No.
Okay. All right, then we can go to paragraph 8, please, which is landowners' interest. Is this the paragraph where you reference that you think Iowa law might apply, or are we not there yet?
I think this paragraph talks more about the landowner confirming or acknowledging that they own the property, that they're not fraudulently signing an easement, collecting money on something they don't own.
Got it. Okay. And the last sentence, do you know what the purpose of that is, where it says landowner relinquishes, releases, and waives all rights of dower, homestead, and distributive shares in and to the easements?
Admittedly, I don't really know the details of that last sentence. It's Iowa specific or maybe a Midwest specific type thing. I'd have to ask our counsel.
All right. Then we can go on, please, to the next page. Property of the company, paragraph 10. I had a question there. This, again, correct me if I'm wrong. It seems to suggest, sir, that Summit can abandon in place the pipeline or any appurtenances or valves or above ground, et cetera, equipment, but yet it still remains property of the company. Can you help me out with that? If you abandon it, but yet you're still claim ownership to it?
That's probably a better question for our counsel on that.
Okay. All right. And then if we can go to the next page, please. All right. So the second half of that first paragraph, it says that this agreement contained the entire agreement between the parties, and there are not any other representations or statements, verbal or written, that have been modifying, adding to, or changing the terms of this agreement. Is that Summit's way of saying whatever we talked about with you before, unless it's in here, it doesn't count?
Well, I think if we made the mistake of making a verbal commitment that we didn't capture in the agreement, our tendency would be to keep that commitment. But I think what this is saying is, in order to alter the terms of the agreement, there would need to be a separate document to do so, it would need to be in writing. I mean, obviously, the capitalized, the defined term of agreement here also includes any of the agreement's exhibits, and I know I keep referencing the Exhibit C as a controlling piece of that. So it's not just this document we're looking at, but yeah, if there's anything agreed upon between the parties, it needs to be bound in this agreement, and it also prevents difficulties in remembering what the agreements were. Some of these folks may have signed an easement a long time ago, and it helps remind us, hey, look, nothing outside of this, outside of what's bound by the board, which again, you can reference that in the document that it's tied to Iowa law. It's again, very generic, miscellaneous, typical paragraph to include in any type of a contract, certainly an easement.
And would you agree, just generally, and or as a condition, should this project be approved, to include what's known as a most favored nations clause, so that persons in the future who haven't yet signed an easement wouldn't be able to be treated unfairly, and they would essentially get the best terms that you have granted in prior easements?
No, we can't agree to that.
All right. Would you, for Summit, be able to agree that you will not use the power of eminent domain and sue anyone in condemnation for purposes of obtaining easements?
No.
Okay. All right. Just give me one moment, please. On the surveys, it's true that Summit has not performed or received results from all the surveys necessary to commence this project.
I wouldn't be the right person to answer that. I don't know what we've confirmed or received or what would constitute as what's necessary to perform the project. I simply don't know our survey data.
Okay. Well, you and I have been in court before, and you were testifying there about surveys and the types of surveys, right? And the number of surveys you had. Do you no longer perform that role or have that knowledge?
If I remember correctly, I have to check the court record, but if I remember correctly, what I was describing to you were the various types of survey and the need to conduct those.
Okay.
I don't tally the data. The Scubanek does. I don't know, to your point, and I don't know if I talked about it in court with you or not, what those thresholds are, the amount of data necessary, as you put it, to get a permit. I'm just not that guy.
Okay, but are you aware that Summit has not yet obtained all the Phase 2 geohazard surveys?
I have no idea.
All right. And it didn't look like we were able to get LO4 up, but I am going to offer that as part of the record.
I think we may have found it.
Oh, thank you. Or do you want to do the same thing as we did
Make
before?
sure we have the right one.
Okay. Yep, it should be attachment 4. Thank you.
So page 71 through.
It's probably about 6 pages. Let's see. Yep. 71 through 76. So, Your Honor, landowners would offer from the Bonita Shills Trust, pages 71 through 76, otherwise known as attachment 4, and request that that become LO or landowner 4.
Are there objections?
Yes, we'll object to lack of foundation. It hasn't been established what the document is. Object to relevance. It appears to be a court complaint from a court in Nebraska.
Yeah, I can lay foundation, or I can discuss it more. That's fine. Sir, you and I were talking about that indemnity provision.
Why don't you just lay the foundation real quick and we can kind of go through the evidence motion.
Okay, sure. So, sir, we talked about subrogation and potential lawsuits and liability. I asked you the question about an insurance company, a pipeline insurance company, being able to go back against a landowner. This is an exemplar of that type of a lawsuit. And are you familiar with those type of claims or abilities?
No.
Okay, all right. Well, I'll still offer the exhibit L04.
Okay, the board will admit the Benita Schultz Trust, pages 71 through 76, as the Jorde landowners hearing exhibit 4.
All right, thank you. And I don't have anything
And
further.
give it the way you do.
Yep, of course, thank you. Thank you, sir.
Oh, I'm sorry. Did you say no more questions?
Can you believe it? Yeah, no more questions. Thank you.
Ms. Grunhagen.
Thank you, Your Honor. Good afternoon.
Good afternoon.
I do have some questions about the Exhibit H easement, but since you've spent quite a bit of time on that, we'll talk about some other issues first and then we'll get back to that.
Sure.
Okay. In your direct testimony, on page 5, starting on line 7, wait for a second. You talk about kind of the initial price formula that had been established for setting the price. Okay. And I think you talked with Mr. Jorde just a little bit about the CS2 values.
CSR2s.
CSR2,
Yes.
yes. Could you explain a little bit what the formula price was used for?
What it was used for,
Yeah.
as far as...
Was it the initial offer that was given to landowners?
They did look at CSRs and the county price points along with crop yields, average crop yields, and they looked at the prevailing price of the rotated crops, all collectively as part of the initial offer for ground and for easements.
And was that CSR point per acre, was that filed in the docket? On there's a list of land values by county filed in the docket on October 27th of 2021. Does that sound?
It's possible I wasn't here when that was filed, but it sounds correct. I'm not sure.
And so around the time of the information meetings.
That sounds right. Yeah.
Okay. And what was the formula price established for the temporary construction easement?
So the temporary, I call it temporary workspace, temporary construction easement, that is coupled with what we were pricing as the fee cost of the property. So it's typically 50% of what that per acre would be. Even though an easement really is a discount to the fee, it's limited surface rights. We're not buying the property, fencing it off, farming it ourselves. The use is returned to the landowner. They continue to generate income off of it. We still price it that way as a premium. So we look at the fee schedule or the fee price per acre. Temporary workspace typically constitutes almost synonymous with rent, but we inflate that quite a bit to 50%.
Thank you. And I want to follow up on the last line of questions that Mr. Jorde was asking you. If I can ask the Iowa Utility Board staff to bring up Iowa Code Section 480.9. Sorry, I didn't give them a warning about that one. Are you generally familiar with Iowa's one-call law?
Very generally, yes.
What is the nature of Iowa's one-call law?
Well, I have to imagine it's similar to most one calls. If you got a call before you dig, if you're going to do any excavation activity on your property, I believe it's statutory. You're calling it a law in Iowa.
Yep.
They need to provide operators an opportunity to mark their infrastructure in order to prevent the possibility or the likelihood of that infrastructure being hit during those activities.
And so that I don't ask you for a legal conclusion, would you mind reading the code section that's been posted there, section 480.9?
Sure. An owner of farmland used in a farm operation is defined as section 352.2, who complies with the requirements of this chapter shall not be held responsible for any damages to an underground facility, including fiber optic cable, if the damage occurred on the farmland in the normal course of the farm operation, unless the owner intentionally damaged the underground facility or acted with wanton disregard or recklessness in causing the damage to the underground facility. For purposes of this section, a quote and quote owner includes a family member, employee, or tenant of the owner.
Thank you. So Iowa's one call law, if they're calling in, then this code section would likely apply since it's in Iowa law.
If it's subject to Iowa law, I would think so, yeah.
Okay, thank you. That's all I need for that. Thank you. And were you present the first couple of weeks of the hearing when many of the non-intervening landowners testified?
I was, yeah.
And did you hear some of the landowners testify about that they had CRP land and they wanted to make sure that that CRP land remained, they remained compliant with that contract?
I did.
Okay. On page 6 of your direct testimony, I believe. If we could switch back to the direct testimony. And then lines 15. Okay. We must be talking about different. That may be, yeah, there we go. I'm going to come back to that. Let me get the right page number on that. I do have a hearing exhibit I'd like to hand out. I should say, I want to talk about IFBF Hearing Exhibit 2. It was handed out earlier this week when Mr. Powell was testifying, and then he suggested that Mr. Rorie would be the better person to ask about that. I do have some additional copies in the event that folks were not here at that time. Thank you. It was handed out already, but in case somebody doesn't have it. Okay. All right. We'll go ahead and talk about this, and then we figured out what it was in your other testimony.
Okay.
This is the page. So, okay, could we? This was a data request that Summit responded to some questions that IFBF had. Did you assist in this? This was last September, last fall.
I assisted with parts of it, yes. And
Okay.
it didn't answer all the questions, but the ones that related to my stuff, I did.
Okay. Could you go ahead and go down to the second page? Okay, did you assist with paragraph C? I'll give you a minute to read.
Yeah, bear with me 1 second.
Yep, I'll let you review it.
I'm sure I provided input on that one,
Okay,
but if I didn't, I certainly agree with it.
okay. And so is this a commitment that Summit is making to landowners with regard to those contracts?
Absolutely.
Okay. And similarly with paragraph E, could you review that one as well? Also relating to the CRP contracts.
I didn't weigh in on that one, but it's very familiar to me and certainly a valid commitment.
Okay, thank you. Your Honor, I would like to offer into evidence IFBF Hearing Exhibit 2.
Are there objections?
No objection.
Sorry, Mr. Auditor, was that no objection or objection?
No objection, sorry.
No problem. All right, the board will admit the exhibit as Iowa Farm Bureau Hearing Exhibit 2.
Thank you, Your Honor. Okay, also dealing with CRP contracts, let's go to the staff report rebuttal testimony on page 6. In lines, starting on line 15. In that area there, okay. In this question, you're also responding to concerns of landowners regarding CRP. Is that correct?
That's correct.
Okay. And the response here refers to language in an easement.
Yes.
Is that language that is only offered if a landowner asks for it?
Well, there's really two answers there. Yes, if a landowner asks for that and they feel like they need that in writing, we immediately put it in the easement. But the easement itself, the way it's worded when it comes to damages, is that if it's not in that damage calculation sheet, in other words, if we haven't cited CRP damages on an upfront basis, which is very rare, but if it's not in there, then we're on the hook for them anyway. So whether a landowner executed an easement with us at some point in time and didn't get CRP language put into their Exhibit C of the addendum to the easement, whether that's there or not, we are still obligated to pay those damages because those are damages that are not captured on that calculation sheet. They're not a part of the crops at all, right? So if someone had residual damage as a result of the easement, in this case being partial forfeiture or partial unenrollment in one of these programs, then we would have to pay for it because it wasn't covered in the initial consideration via the easement. So whether the paragraph 3 or 4, depending on what state we're in, as far as damages is concerned, is essentially omitted there, which means we would have to pay it, or whether we went out of our way to put that language in the Exhibit C to temper that concern with the landowner, either way we'll pay it.
Will you also pay if it's an Exhibit H landowner whose land was subject to, or who went through eminent domain?
And they were subsequently unenrolled in CRP as a result? Yes.
Yes.
Yeah.
Okay. Thank you. And similarly, with some of the landowners, did you also hear some concerns about just farm program eligibility in general?
Could you ask that again? I'm sorry.
When you were listening to the landowners testify earlier in this hearing, did you also hear some of them express some concerns about just conservation compliance or farm program eligibility?
I did. Yeah.
Okay. I have another exhibit.
Okay.
And this would be IFBF Hearing Exhibit 3. Thank you. And again, this is a data request that was served on Summit and the responses to that. Were you involved in responding to this as well?
Very little. I think at first glance, this is talking more about nationwide permits, PCNs, things of that nature, corridors, et cetera, it's way more in the,
weeds?
well, it's way outside of my scope. I mean, although I'm familiar with these terms but I tend to shy away from them in a hearing because it's not my expertise. John Schmidt, I believe at some point we'll be visiting about these types of things, but I may not be the right guy.
Okay. Could you look at paragraph E? Because I think that's might be more in line with.
Okay.
And is that, are you familiar with the policy of Summit with regard to paragraph E?
I am. I'm not very familiar with the restoration requirements dictated by the Corps. I'm familiar with our mitigation plans and our environmental construction plans. I'm certainly familiar with the first part of this that said that in the unlikely event that they would lose eligibility, that we would need to keep them whole on that.
I guess right now I'm just trying to establish foundation that this might be something you recognize. I can ask questions of
Sure.
Mr. Schmidt about it, and I can save those questions.
I certainly recognize the document. It's just there were parts of these questions that I wrote almost directly, and others it was delegated to people that speak nationwide permits better than I do. Yeah.
Well, I'll save my questions about this for Mr. Schmidt, and but in the meantime, I'd like to offer IFBF hearing Exhibit 3 into evidence.
Are there objections?
No objection.
Hearing no objections, the board will admit IFBF hearing Exhibit 3.
Thank you, Your Honor. I just had, before we get to the easement language, I have one more kind of detailed question here. Other than the initial information meeting letter that went out to landowners, did your land agents ask again whether a landowner had a farm tenant? Or when did any conversations occur about that other than the initial informational meeting?
Oh, sure. They ask that all the time because tenants can change. It's not always readily offered to us who the tenants are, but we tend to ask that very often, certainly with folks that we haven't reached an agreement with. We have an obligation to ask that or try to figure out to the extent that we can who the tenants are. So we ask that very often.
Do you know of any, I guess, any reason, or I don't want to ask you to speculate, but any reason why when we were going through the landowners for the last couple of weeks, there were quite a few properties that didn't have a farm tenant listed on them, but the landowner would then testify that there was one? Do you know what reasons there might be about why it wasn't listed on the Exhibit H's?
The primary reason for that is that they didn't tell us. So they may have said it here, and you saw some reluctance to even share who their tenants were here. So it's the same reluctance in an individual conversation in their field or at their farmstead. So the challenge with tenants is that the vast majority of them are not public record, right? There's so many tenant arrangements that are handshakes or verbal, and they also change growing season to growing season. So unless the landowner shares it with us, it's very difficult to know exactly who the tenants are. We can give it our best guess, which we've done, to the extent that we can figure it out. But even that's speculative. The primary source and the catalyst for us knowing who the tenants are the landowners sharing that with us. So if some instances there's been landowners that won't talk to us at all. So of course we haven't really been able to ask other than maybe in informational packages and things like that. And then there are other landowners that won't share that information. And we try not to insert ourselves in between a landowner and a tenant. There's a variety of types of relationships there, and it's really none of our business in terms of those dynamics. But if a landowner won't tell us, then we have no idea.
Have you and your staff talked at all about how to get landowners to be comfortable sharing that with you, given you're looking at filing these as eminent domain actions?
So we don't look at methods to get them to share it. You know, that just is, that comes with the individual and what talent and skills they have to be relatable with folks and see if those folks are comfortable sharing that information. We have stressed the importance that we've got to try to figure that out, that if we don't make an attempt, it's much less likely that it's just offered up. So we have to ask, but I don't give them a method of asking. It's just, you know, please check with the landowner, see if they're comfortable with us knowing who their tenant is so we can include them as a form of an interest holder on this project. And we've got to do that. But again, if we don't know, we don't know.
So in the event that the landowner doesn't tell you who the farm tenant is and construction is started and all of a sudden you've startled a farm tenant who didn't know about it, how is Summit going to proceed in that instance?
Oh, well, it's a case by case, but in general, if we're constructing on the property, we have an easement there. Depending on what type of easement, I'd have to look at the Exhibit H rights. Admittedly, I'm not real sure what it says about tenants, but we can look at it together and see. But our voluntary easement basically says, look, this is consent for the landowner and the tenant, that the compensation or consideration paid via this agreement includes any damages tied to, if leased to a tenant. So we would feel it's pretty enforceable. We have the right to continue to be there. Now, whether the landowner paid their tenant or if there was some other arrangement made, or maybe this is a new tenant and the old tenant got the money from the landowner, I can't control that. I don't encourage that, but I can't control that. And I certainly can't dictate to a landowner how they're supposed to interact with their tenant. That's not my place at all to do that. So I don't tell them one way or the other what I suggest. What I'd like to avoid is what you just described, which is someone showing up out there surprised when it would have been of record. It would have been clearly stated in that agreement. There were real dollars exchanged, and typically much prior to that construction occurring, so plenty of time for that communication to have happened. But if I don't know the tenant, there's no way for me to tell them.
As a part of the voluntary easements, I think you mentioned also the crop damages were paid at that time.
Could you ask that again? I'm sorry.
At the time that you acquired the voluntary easements, were crop damages also paid at that time?
The vast majority, yes. At the project's onset, the original compensation structure was to pay the crop damages either right before construction or right after construction. When I joined the project late January, early February, that changed and we turned it into an all upfront payment unless the landowner dictated differently, that they wanted parts of it paid the next year or whatever it was. So it's both. There are some landowners right now in Iowa that initially were paid the permanent easement, the temporary workspace, and the damages were deferred. We have since trued up the vast majority of those. I don't think there are any hanging out there that haven't been paid in full upfront at this point. But the method of compensation was twofold from the project's onset until early 2022.
And so so in the event there's a farm tenant, those crop damages were paid to the landowner, or were they paid to the tenant?
The landowner drives that. So if the landowner defers those damages to their tenant, then obviously we know who they are. We get a W-9 from them. We get a tenant consent. We pay them that check. So it's a variety. There are instances where we've paid the tenant directly if the landowner did a payment directive. And there are many instances where all of the dollars go to the landowner. So the landowner drives that for us. We do what the landowner tells us to do on that.
So what will happen in the event that you paid the crop damages to the landowner and it's actually, when you start construction, it's the farm tenant who owns the crop and their crop was destroyed?
Can you help me understand what do you mean? What would happen? What action would we take? Or?
Yes, what action would you take?
I feel like our part of the transaction would be done there. I think we certainly wouldn't want to double pay simply because the landowner didn't communicate with their tenant. We feel like that we would have documented that we paid for those damages and those damages were covered as part of the consideration of the easement. It's unlikely that we would double or triple pay folks that kept coming back and saying, well, I didn't know. I don't know what the law says about that in Iowa. I don't know what we're required to do there. I can tell you in general, in all the pipeline right-of-way that I've managed, it is half of one hand of of instances where a tenant has shown up and didn't know a pipeline was coming. And we're talking about 5,000 miles of pipeline, a lot of it farm ground. So it's not very common. But we would want to get in touch with the landowner and circle up and talk about, here's what transpired, and we cannot stop our construction crews for something that we've already paid for. We need to work this out. If concessions should be made some way, then we would explore that, but I can't commit that we would double or triple pay.
Have you entered into any agreements with farm tenants directly?
Agreements, meaning easement agreements?
Or contracts with them? Because if they have a lease, I don't want to get into, again, legal conclusions, but if they have a lease on the property, they have possession. And the pipeline would be interfering with that possession. So do you have any separate contracts with the farm tenants at all?
We do. We have what's called a tenant consent. It's coupled with the easement document, and it's typically procured at the same time the easement is procured. And that would be in every easement package that I know of that we've put in front of landowners. We try to procure those during the cancellation period at the latest. But we, most of the time, I would say the vast majority, gain those at the same time we pick up the signed copies of the easements. And it's a document, and I couldn't quote it word for word. I'd be glad to submit it as an exhibit at some point. It's just a consent with the landowner, the tenant acknowledging, yes, I understand the terms of this. I understand dollars have taken place. I have no problem with this pipeline coming through. So we could submit that if you wanted it. But yes, there are documents that we put in front of tenants. To the extent that we know who they are, they talk to us.
Okay, very good. Thank you. Okay, so with regard to the Exhibit H easements, is all the easement language substantially the same from Exhibit H to Exhibit H request?
There are some differences.
What differences?
The temporary workspace has a fuse on it. It's a 2-year fuse versus a written notification within a reasonable time frame of completion of construction. So it's a limited 2 years from commencement of construction. The access easement is a little bit different than what Mr. Jorde was describing on the voluntary easement. It's actually substantially different, but intent's about the same anyway. It's got to be shown. Whereas in the voluntary easement, not in all instances is that access easement shown. And it's for emergency purposes, et cetera. So there's some differences there.
Let me restate my question. I understand there are differences between your Exhibit 1 and the Exhibit H easement language.
Okay.
My question is, if I brought up or have the staff bring up an Exhibit H with the easement language, would they all be substantially similar? So if we looked at one, we would be essentially looking at all of them?
I misunderstood your question. Yes, they're all identical, with the exception of some of them ask for surface sites and some of them don't.
Okay. I'm just going to pick one that I think we have looked at in the past couple of weeks just as an exemplar, but as you've identified, they're all the same. So if we could pull up PA-006, or if there's another one the staff wants to pull up, that's fine too. And while we're waiting for that, so the Exhibit 1 that Mr. Jorde went through with you, that's the voluntary easement template, is that correct?
Yeah, it was our base generic form of an easement. I didn't scroll through the whole exhibit to see whether our Addendum C or Exhibit C was tied to it, but it's our generic form for a base easement.
Just so I understand, do you know, is that form voluntary easement, is that something that someone is asking the board to make a decision on?
No.
And so,
I don't think so. I have no idea. But no, I'm certainly not asking for a decision based on those terms.
okay. And that agreement is something that gets negotiated between the landowner and Summit?
That's right. So there's a wide variety of the final results of those agreements. But yes, that is an agreement that gets negotiated back and forth with the landowner and our folks.
And so the language in the Exhibit H's that, if you could just, on that particular one, it might be page 3. Yeah, page 3, there. And so that language, is that language something that Summit is seeking permission as a part of their eminent domain request?
That's correct.
Okay. So I want to ask some questions about this particular one. And as you noted, there are some differences between your Exhibit 1 template and the Exhibit H.
There are.
One of those, you mentioned the access easement is different. In the Exhibit 1, it talks about the access easement being non-exclusive. Are you
right.
familiar with that term?
Yes.
Okay. And that language is missing, or seems to be missing from the Exhibit H.
I
Is
don't
that
know.
an intentional difference?
No, that's not intentional. And also, I think the way the Exhibit H is structured, it would need to cite that there was an actual access easement there. So it says access easement, if any, and it would need to be defined in there. Otherwise, you can assume there isn't one other than for emergencies. I mean, I'll unpack that a little bit for you. So if
Yeah,
there was a valve site there, you would see some obvious things about an access easement. And the valve site would be an exclusive easement, right? It's got to be fenced off. I don't have one of those examples in the back of my mind to refer to see how exclusivity is handled on the road itself to that valve. But I could say that our access easement would be a non-exclusive easement. That's
To a valve
regardless.
site would be.
Well, valve site, I mean, we would hope nobody would tear it up or cross it too bad. Still don't want them to interfere. We got to get to our valve, but it's still probably a non-exclusive access. The valve site itself is exclusive.
And similarly with the temporary construction easement, the word non-exclusive was included in the Exhibit 1, but it's not in the Exhibit H easement. Was that an intentional difference?
You'd have to ask our council who structured that, whether they intended to omit that or if this is just a typical list of Exhibit H rights that are asked for. I don't know if it's a bare minimum type thing, but I don't know if exclusivity was purposely or intentionally excluded or included in certain spots versus others. Couldn't tell you.
I guess just for those that aren't aware, do you know what the difference is between an exclusive and a non-exclusive easement?
It's a long answer, but I'll try to give you the short version.
Please.
So an exclusive easement, the easement holder has substantially more rights about how that easement is treated by the landowner or any other operator. They have a lot of rights that, depending what state you're in, and what they're in, filing of injunctions and what that would require for another operator to cross you. They have a lot more say in their crossing requirements. They have a lot more say in general of what happens on that easement. Exclusive easements is becoming more rare these days. Non-exclusive easements is what we're seeking, right, for the pipeline easements, which means some of the things I touched on earlier, typical farming practices, the ability to generate income outside of some minor, shouldn't say minor, but outside of a short list of restrictions, drilling wells, impounding water, etc. The landowner and future landowners have the use and enjoyment of that easement so long as it doesn't interfere with the specific rights that are granted. An exclusive easement, it operates a little bit more like a fee ownership. Not entirely, but it's much more of a hybrid type fee arrangement where if another pipeline wanted to cross our pipeline or a tile line wanted to, or a drainage district, or I don't know, pick an example, other than us pointing out what would totally interfere or unreasonably interfere with our pipeline, there's no 40-page thick crossing agreement that we would make that operator sign, and if they didn't, we file an injunction and they have no legal right to cross our easement. So that was supposed to be a short version. The short version is that non-exclusivity waters down the rights substantially of the operator. I mean, it's Venus and Mars.
exclusive easements are rare as a result of that because it's much more of a forfeiture of rights. That's why the only exclusive easements we're seeking, my understanding, would be the valves, because we don't want anybody trying to do something inside that valve for safety reasons. They need to not get inside the fence. There's no reason for them to be in there. We need exclusive ability. I don't want another operator getting in there and sharing space without my full consent. Everything else is non-exclusive.
So for example, the access easement, is there an intent by Summit to exclude the landowner from accessing that and through that same path?
No.
Okay.
I mean, sometimes it's a case by case, depending how that road approach is. But no, we don't have the intent of them not being able to use that road.
And similarly with the construction easement, you mentioned 24-month period of time on the construction easement. Is there intent by Summit to exclude the landowner from the easement during that 24-month period?
No, only to the extent that we don't want the easement obstructed, and we certainly don't want folks getting in the way during construction. So for safety reasons, we're paying for that right, and they're welcome to farm that the entire time until we construct. So we have no problem with them accessing that workspace. It just makes sense that once we're constructing, that they not spend too much time getting in the way of the construction crews. That would be obstructing with the rights that were granted in there for installing the pipeline. So other than that, I don't know. It's a non-exclusive thing.
Okay, thank you. Also in Exhibit 1, the easement, it directly references the description. It provides an exhibit, and the Exhibit H easement language doesn't specifically identify the location by saying like exhibit, as described in Exhibit A. Mm-hmm. Is there a reason for that?
The Exhibit H template itself, the last page is the meets and bounds description of the location of the easement. It's very different than voluntary easement. I don't know if we can scroll through there. Maybe I could talk about that, but it's...
Just scroll down to the pictures. I should say drawings. Use a more proper term.
So if we go one page further out, that's what I'm talking about there. Well, I was wrong. The next page would be...
Are you looking for the drawings or the legal description?
That right there,
okay.
The legal description.
Okay.
So whereas in our voluntary easements, we have an Exhibit A that talks about the parent parcel, and they pare it down to some of the area where we're looking at installing the pipeline. This is exactly specific where we need to install the pipeline. So we have much less leeway in Exhibit H to vary the pipeline route. We have to stay within that 50-foot stretch. But the reason I think there's no Exhibit X or whatever it would be to have a property description is because it's right there.
So does that get filed with the easement language as well?
I'm not sure. I'm not sure what all gets filed, but as far as what gets recorded in the courthouse, I believe so.
Okay. And so the intention is to only ask for an easement over what's the drawings and the legal description?
That's right. Yeah.
Okay. Thank you. Also in the Exhibit 1 versus the Exhibit H easement, in the Exhibit 1, it has, for the size of pipe, it has a blank space to fill in. Mm-hmm. And in the Exhibit H, it says 24 inches. Mm-hmm. Is that correct?
That's right. Well, the Exhibit 1 was our base generic form. If you were the landowner, it wouldn't have a blank. We would say 24 inches in it, but that was just with varying sizes. That was what was submitted as an exhibit. But yes, they would both say 24 inches.
Would you agree that there is a difference between placing a 6 or 8 inch pipe and placing a 24, 30 inch pipe through
Like
someone's property?
Construction-wise, or?
Construction-wise, impacts?
Construction-wise, certainly, there's different constraints when you have a heavier one or a larger pipeline versus a small. I don't see the huge difference there, but there's different methods of construction. I'm not the guy to get into that. If you're asking if there's a difference between a small diameter pipe and a big diameter pipe, sure. The Exhibit H's all are going to be congruent, consistent across the board. That's typical practice there for, I think they're all going to say 24 inches. The voluntary easement, almost all of the time that we work out with the landowner has this Exhibit C that I keep mentioning, and that pares down the diameter, within a few inches typically of what's going to be installed. So every base easement, I say every, thousands of the base easements will say 24 inches in that opening paragraph or in that granting paragraph for the pipeline easement, and then have an Exhibit C that pares down that diameter. Sometimes it's both. If it really is a 24 inch, it would say it in both spots. But that was instituted after the project's onset for the concern you just mentioned. Some folks wanted to say the exact diameter. Some folks didn't care. Some folks are fine with it being able to be a varying diameter. They don't want to deal with another easement. Fine, you got to come replace it. Just pay me the damages, which the easement allows you to. It's a mixed bag, but our base easement, it's a long answer to your question, but the base easement in Exhibit H, you're going to say 24 inches in the first pages there.
And does the Exhibit H easement allow Summit to change the size of the pipe?
I believe so.
Okay. So if you placed a 6-inch pipe through someone's parcel, the easement says 24 inches. Is Summit also looking for the right to come in later and put a 24-inch pipe in there instead of the 6-inch?
I don't know that we're looking for that. I think it would allow it. Certainly the flexibility of being able to replace that pipe with a larger pipe, I think so. But I think we're venturing into what our council wrote for Exhibit H rights, and certainly there would be an advantage of being able to adjust the diameter of that pipe. I can tell you the intent on my end, or really what I'm hoping it mitigates, is an Exhibit H is a function of eminent domain, right? It's an Exhibit H is also a function of the board process, but it's as you mentioned, it's part of what you'd be seeking through eminent domain. If you have a piece of property that we had to go through the unfortunate circumstance, which I hope we wouldn't, but if we did, and had to file eminent domain and go down that road, the last thing on the planet we want to do is do it twice. So if your neighbors had signed voluntary easements, had an Exhibit C that showed, just call it a 16-inch diameter, right? The risk assessment we do when we look at that is say it's much more likely that if we had to change the diameter on that pipe on their easements, that they would work with us on that. We would be able to amend those. If we're in a situation with you where we exhausted years worth of effort and resources trying to reach an agreement with you, and then we went through the dually painful process of eminent domain, which is not fun, certainly not fun for us, and it's never fun for the landowner. We don't want to do that twice. So we want to get the basic rights that we would need to operate this pipeline system and not have to disrupt that person's program again, or have to go through that process again. So that's part of the intention there, but also all of the Exhibit H's are really going to look the same.
For this project, is it necessary that you have the ability to change the pipe size?
I think so. I'm certainly not the engineer that draws up the reasons why, but I think it's good to have that right.
So is Summit looking at changing the project and increasing the capacity then, or why would they need a larger pipe in those areas?
That's a great engineering question. I'm certainly not looking at expanding the diameter of the pipe, but if there was a reason that warranted that for hydraulically or some other reason, they would certainly want the flexibility to do that without having to amend the easement. But as it sits right now, we have over 1,200 over 1,200 landowners that have reached an agreement with us. So all of those landowners would have to be amended if we change the diameter somewhere.
And also in the easement rights, I think you briefly talked to Mr. Jorde about this already, but changing the routes of the pipe, are you looking at only changing the route of the pipe within the easement area? Or are you looking at changing the route of the pipe within the parcel?
I mean, as it relates to the Exhibit H's, it would be in the easement area.
Okay.
If it's a voluntary arrangement in which the landowner is comfortable for one reason or the other, for more flexibility, then we would work that out individually.
So that would be another difference between the voluntary versus the Exhibit H's?
That's right.
Okay. And then you also discussed abandonment in that. Is the intention with the Exhibit H's is for the abandonment law to apply? The
Yes.
reversion of use
Yes.
provisions? Okay. And does Summit have an intent to, with the Exhibit H's, give Summit the choice about whether or not to leave it in place upon abandonment?
No, I think that the rules would apply about abandoning in place being default unless the landowner elected otherwise. I can say on our standpoint, we're fine either way.
And then also as far as the scope of the Exhibit H easement, it talks about allowing telecommunications, power lines, and any other such equipment that's used or useful. Is there any intention by Summit to place fiber optic or electric lines or lease that right to do it in order to provide services? Those kinds of services?
Not that I'm aware of. I think that what you're looking at is just generic language that talks about anything necessary to run pipeline facilities. So we certainly don't have the intention of running power lines all over these easements, but if there's a rectifier that needs power to it that's tied to cathodic protection, we'd like the ability to do that. Again, all for the same reasons I just stated. How painful it would be to have to go back to a landowner over a rectifier to keep electrons rectified cathodically on a pipeline. That may require power. Fiber optic, Mr. Powell touched on that earlier. I'm not a fiber guy. Don't know if we would or wouldn't. It's not something I talk to landowners about. But what you're looking at is generic, standard pipeline facility language about appurtenances.
And so Summit is not looking to lay fiber optic line and then, or lease that right to somebody else to sell internet services to somebody?
Not at all. And that the internet services would not be tied to the operation of a pipeline facility. So I think that'd be a violation of the easement. Not lawyer, but certainly not our intention.
And similarly with electric lines, there's no intent to lease the ability to lay electric lines for somebody to sell transmission services or electricity services?
No, that's certainly not our intention. We do have the intention of placing some electric lines down access roads to those valves. We need to power those. Launcher receivers, same thing. But no, we have no intention of partially assigning our easements to a third-party power provider that has nothing to do with us. I don't know that we could, but I know that we shouldn't, and we have no intention to.
So your uses of that equipment is the intent is just to use it for purposes of operating the pipeline?
It's entirely for that purpose.
Okay. All right. And then also be in paragraph 5 of the Exhibit H language, and we can scroll back up to that. It talks about temporary and permanent gates that'll be installed. So I assume if fencing is torn out, there's already rules regarding that. My question is that regarding the gates, say if Summit places gates at the end of the easement so they can get access from the road, is that something that, like if it was a locked gate, that they would also provide the key or the combination to the landowner to access the property
typically
that way?
that's the case. I mean, if they're typically key blocks, certainly provides the landowner the ability to, we could cut a link and they could put their own lock in that chain as long as they don't put it past ours. But if the question is whether the landowner would have access through that gate, yes, they would.
Yep,
We'd
that's
figure it out one way or the other.
True. True. Thank you. believe that's all the questions I have.
Thank you.
Okay, thank you, Ms. Gruenhagen. Okay, we're getting dangerously close to 3 p.m., so I just want to I don't want to cut anybody off, but I want to get a sense of how much time we're going to need. Mr. Murray's shaking his head like he's going to need more than 15 minutes. Okay, that's fine. Okay, that's fine. And Mr. Taylor, I assume you'll need, that's fine.
Imagine maybe 20 minutes or so with him.
Okay. Mr. Meyer. And we're not gonna hold you to it. If somebody's only got a couple, we can squeeze them in and be done, but,
Mine are probably 15, 20.
okay. Ms. Colas, I see your name tag. 5 minutes? Mike, use your mic. Please.
Probably 5 to 10 minutes.
Okay, let's do this. I've got everybody listed down, so we'll make sure that you're not left out. We'll have Ms. Colas ask her questions, and then we'll hit the pause button. Go ahead, Ms. Colas.
Good afternoon, Mr. Rorie.
Good afternoon.
I have some questions. I'm Jean Colas with Colas Family Farms, and I've had experience with your land agents and trying to negotiate an easement agreement. And since you were the one who you stated who hired and trained these agents and they work under your direction, is that correct?
Yes, I did hire them, either indirectly or directly, yes.
And you held them to certain standards.
We do our best to, yes, ma'am.
Okay. And you have not, you said earlier that you had not terminated anyone's employment with your agents, with you.
Oh, no, ma'am. I've certainly terminated people on our project. I'm not sure I understand the question, but I certainly have terminated folks on this project.
Okay, I misunderstood your response then. Okay. Well, I'm going to start with a few things. When I was initially received the easement agreement, I talked to land agent and I asked him if there was a possibility of a route adjustment. And he said, absolutely not. There is no negotiation because of safety protocols. Is this a typical answer on the first contact with the landowner?
Sometimes, there's areas on this pipeline project where route fluctuations are much more difficult or not an option than others. It's a little bit random and it gets pretty scientific, but there are certain areas that right off the bat, we meet with the landowner, and if they ask for a route to be changed, we know that it's not feasible, that this is the only thread of the needle we can go.
Even if it was on the same parcel? It was not out of the parcel? Would that create a problem?
It's, again, there's certain areas where our agents are instructed by project management and others to say this is a zone where we can't move very much. There might be some micro changes and things like that, but I have to go with my agent there. If they told you that it wasn't much of an option, it's probably because they were told that before they got there.
Would that be because of the relationship to an ethanol plant?
I can't imagine that being a reason.
Would it be because of the boundaries the pipe is going through on neighbors to the north or south?
It's possible what they may be encountering as a adverse effect of moving on your ground. Sure, it's possible.
Even if it crosses a waterway, it doesn't make any difference.
I'm sorry, I'm not sure I understand that question. Even if it crosses a waterway, it doesn't make much of a difference to move the pipeline, or I'm just struggling
to relocate it.
There are certain ways we have to cross waterways. It's tough to have some flexibility there. But I just want to make sure I'm answering your question and not answering the opposite there. That if we have a set way to cross a waterway, then that's right. There's some tough constraints there that make it difficult to move.
Okay. We negotiated, tried, the initial easement agreement was ridiculous, okay? And I was questioning, you did answer some areas of how you came to those terms. I was attempting to get those changed, and I gave very valid reasons for the appraisal being incorrect. In subsequent easement agreements, I did not get a difference in rate, even though you indicated that. I did, thankfully, get possibilities of how to deal with the tile they were crossing on the route, with depth, etc., which I was happy to see. But one of the areas that I had big questions was safety of the pipeline and accessibility to the way it's cutting across my land. It really eliminates a huge portion of my property. And 3 sides of my property are farmland for other people, some with easements, some without. And I only have 1 road access. So it's basically a north-south pipe, but the only access would be east and west, completely cutting across. And the easement agreement did not address that right-of-way for pricing to the easement area.
I apologize. I'm not sure. You're doing an excellent job of describing your property. And I have looked at your property. I've seen you here the last couple of weeks. I've heard some of your questions. And so I did a little bit of homework to make sure that I could answer your questions the best I could. I'm not sure I understand what you mean about access east to west. We certainly don't prevent a landowner from going across the easement, if that's what you mean. Or you're just talking about the fact that there would be an easement there and...
You would be going across tillable acres or the farms. You say we can operate going ahead, but if you cut smack dab straight across, because I think on your proposal, it indicated there was a county road to the south of my property, which might have provided access. But that access was terminated when the buildings in the homestead were demolished. And that road has a bridge across it that has not been maintained by the county. So that's where I'm getting, why I wanted to have a discussion, was because of the access to get to. You can't go across other people who haven't signed an easement agreement, correct?
I'm struggling here. Can we pull up your property? Would that help? It certainly would help me if we could pull this up and look at it. So you're talking about a county road that's been abandoned, that's got a bridge on it, and how you guys would be able to maintain and farm either side of the easement. I want to be able to help you, but it would help you help. I don't know her Exhibit H number or...
Why wouldn't your agents discuss this with me prior to this procedure?
Well, I'm certainly, not to offend, and I don't think there's much utility in me disagreeing with you much. And it's not my intent to, but you've got some pretty reputable people that have visited with your farm manager. We have reached agreements with the vast majority of landowners and farmers that are managed by that farm management group. Those were done a long time ago. They were very amenable. They had extensive terms about tile and a lot of other concessions in those agreements. We were under the impression from their farm manager, I believe his name is Grant,
Correct.
A long time ago, that the signature pages and the packages had been sent out to you to sign. We were certainly disappointed, and it was unfortunate that they weren't signed. We've tried to keep in touch with your farm manager and can document that very easily. We've tried multiple attempts to reach out and see how you guys were doing, if there's anything we can do to answer your questions. We've had some of the best supervisors and leads that I've employed in Iowa reach out to you and to your farm management group over the course of a year. We're still here to visit with you. I'm thrilled to visit with you and see if we can work something out and get those questions addressed. The answer we've gotten most of the time, and these are from people that I would certainly vouch for, that you're running a business and you're very busy. We were under the impression that you guys, everything had been agreed to through your farm manager. That was our primary contact. And that you had some questions, but we didn't know what the specific questions necessarily were. We sent you all the project information we could think of, including some direct testimony from Mr. Powell. We reached out to Grant repeatedly. How are we doing here? What can we do to help? And that's where things left off. So again, I can't stress this enough. I am not trying to argue with you about that, but I have to dispel the notion that we haven't tried to answer your questions. I just think you guys have been pretty swamped lately.
I also had 3 surgeries that I was recovering from.
Understood, and that's a valid reason, right? But it still doesn't change the fact that we've tried really hard to visit. So I don't know that the notion that we're not here to answer your questions, I'll be glad to visit with you at any time, or certainly put you in front of some people that will answer your questions if you have them, but we just simply need a dialogue with you.
Yeah, because
I'm glad you recovered from your surgery.
I just got slick merchandise, same 3 times, same information.
Yeah, I think one of the information that we sent, pieces of information, simply just had a new year on it because we expected all of this to be resolved last year. So that's just a whole new year, and that's why we sent that in the event that you elected to sign those easements. But again, we are glad to visit with you and try to work out any of your safety concerns or any concerns for that matter on your property as it relates to the easement. Our door is always open for that.
It hasn't been up to this point.
Well,
When I've asked for information, I was told they couldn't discuss it, or like you said, the route couldn't be changed.
Well, asking for
access.
information and asking for the route to change can be 2 different things. But again, I'd be glad to visit with you about that. I'll be able to give you the brass tacks on how that looks and what answers we can provide you. Depending on what you're asking, there's some things I'm not allowed to answer, but we've been available to talk.
You also indicated that most people have received a one-time upfront payment.
Most people that have signed
Well,
these.
I was under the impression that it would only be a upfront one-time payment that would go as a capital gain. Is that correct?
Well, diving into capital gains, not a tax professional, but no, there's 2 components there. I would encourage you to talk to your CPA about that, but there's 2 components when it comes to the tax side of this. I can talk in layman's terms about it, but it's a two-way scenario. There's capital gains and ordinary income. There's a 1099-S and a 1099 miscellaneous. And the permanent easement falls on one, and pretty much everything else in its subcategory falls on the other. Either way, that's a tax scenario in which I cannot manipulate. It's just tax law. So it's not one or the other. The cap gains typically applies to the permanent easement. Typically, again, please check with somebody. I'm not a very good CPA. But
I did.
the temporary workspace, the crops that are forfeited, all of that is technically ordinary income or rent, however they want to subcategorize that, and that would fall under a 1099 miscellaneous. So it is rare for a right-of-way agent to go to the extent of what I just did, because we run the danger of saying it wrong and then we misled someone, but I'm comfortable telling you that. So right-of-way guys and gals are not tax professionals, but they can't tell you you're going to get 2 1099s unless it's a drill with no damages.
But it was in the same calendar year, so they're pretty much both taxable.
That sounds right to me. I don't determine what is and isn't taxable. I can just tell you which buckets they fall in.
Well, it wasn't true that so that person did not have the authority to answer if I could take the payments on different years.
Well, if you wanted to defer a payment to the following tax year, sometimes we can do that. Landowners request that. We don't extend those out over long periods of time as an annual payment. It just whatever can help accommodate you in terms of your preferences in a 12-month period.
Wouldn't it help most of the landowners in Iowa by breaking it out instead of a one lump sum?
You'd be surprised. There are hundreds of people that have said, absolutely not. I want it all up front. I want it right now.
Okay, what is the age demographic of Iowans?
That I can't answer. It's a great question. I have no idea.
2/3 of the landowners are 65 and older, and 37% are 75 and over.
Okay.
Does that sound right?
I have no idea. I would not be a good judge of that.
So a lot of those people have to take RMDs, pensions, and that kind of thing in the course of a year, and the rent and all their income, and their Social Security benefits are on total gross income, regardless of how it's classified. And if they have to take a hit of income, probably a substantial amount, in the course of 1 year, it affects their monthly Social Security benefits. They get less money the more money they make. And a lot of them are widowers or whatever, so they even have a smaller level. Well, I'm not saying it right, but there's different stratas of income on what is taxable, and different stratas of what Medicare A, B, and D will take out of the monthly Social Security checks for these retired individuals. So by a lot of the seniors receiving this one-time payment, it will affect their income, reduce their income for the next year.
I'm sorry, was there a question there? Or?
Well, I'm just giving you some information of it's not that great a deal when you look at total gross money that you're willing to pay, because it actually hurts. The seniors are probably over 70% of the landowners in Iowa. Do you agree?
I don't agree that it hurts people. I'm listening to the scenario you're describing. I think there's one caveat there where you mentioned that they get less money. They may get less money from that program, but they get money from us. I understand the income brackets and what you're talking about there. We sympathize with that, but we can't not install infrastructure based on someone's tax situation. Nothing would ever get done. If the landowner requests that an easement payment be deferred or partially deferred within a 12-month period to help quell some of that or make that more palatable, then we're always willing to comply with that. But I can't adjust payments and payment structures beyond that, because I can't get into a spot where I'm breaking rules. And so I understand the concern there. It hasn't been a huge concern with the Iowan landowners, and we're talking 1,210 that have signed easements. That topic has come up maybe once in 2 calendar years, now twice. So it's not a very common complaint or concern from a landowner, which leads me to believe they're comfortable with it or they've adjusted to it. But I can't manipulate things tax-wise for you or anybody else. As much as I would want to make this less stressful for you, I have to stay within a certain lane, and I'm going to do that.
Well, their net income goes down, and it affects their tax rate. It can increase maybe one or two tax brackets.
Understood.
So that is the one-time payment could be detrimental to the landowners' taxable income and the income taxes they are forced to pay. Correct?
I take your word for it. I have no idea.
Also, I question the real estate evaluation. Can you clarify for me, was that basically 50% of the value of the land?
The real estate evaluation, can you help me understand? Even the offer, or?
Your calculations, was it based on the appraised value or on real sale or sale of the property for the current value?
It's sort of a hybrid. So we look at the CSR2 scores for the ground. Those tend to not change, right? They were pretty set, 2012. We look at the CSR2 scores, then we look at Iowa Land Survey data for comparables, and we look at some of our own data for comparables, and we typically pick the higher of the two. We multiply those two things together to come up with the per acre for that tract. So let's call it 5,000 an acre. So then we would say the temporary workspace is 50% of that per acre. So now we're at $2,500 an acre for the temporary workspace we're borrowing from you to construct the pipeline and install it. Then we would look at the value of the crops, typical yields, try to take a weighted average of that to make you whole on that, and look at it a 3-year period assuming a rotated crops. That all bundled together is the compensatory offer that you see.
And what year did you base those numbers on?
Well, it looked, initially the project's onset was in 2021, but we keep an eye on things. If the price of corn or beans change, if there was a substantial difference in that per acre, that would exceed what our premiums were. So if our premiums already captured any fluctuation, and that's sort of on purpose, that if our premiums capture that fluctuation, there's no real sense in adjusting it, unless you told me to. Some landowners have, and some don't care, and some agree with our pricing.
We were questioning that, Greg
Yeah.
questioned that,
Yeah, so,
and it was not changed.
well, I'd have to go back and look at the other landowners tied to that farm management group. Certainly can't discuss their compensation here. I'd have to look at it, see if they adjusted them. But regardless, it makes no difference to me. If you feel like it's justifiable that your per acre is a little bit higher, within reason, so I'm not breaking IRS rules here, then we'll adjust that. It doesn't change the total amount of compensation. It changes how much is allocated that way, because the total compensation is far above beyond what that value is. I don't know if I'm doing a good enough job of making sense of this, but I'm trying to.
Yeah, I'm still concerned about the right-of-way access to get to the easement area for construction.
Okay.
I'm not aware that anything was paid for that land to access that.
Anything was paid to access the
Well,
land.
anything was negotiated related to maybe having a completely separate track.
Well, this right here, I mean, unless there's an access road to get to it, they'd go up and down the right of way.
So you go around 3 to 5 miles to get to construction?
I'm not following why we'd go around 3 to 5 miles. But at this white line, we would just take our crews down that white line.
Down the easement area?
That's right. That's right.
Okay. I didn't get that answer before.
Okay.
Thank you. No more further questions.
Okay, thank you. So with that, we will recess until Tuesday at 8 a.m. Yes,
So,
Mr. Jorde?
yes, thank you. Clarification, is the board able to tell us what the intention is of how long? I mean, are you intending to go the entire month of September, or I'd like some clarification on what the intent is for the remainder of the hearing?
I think we have a lot of witnesses to go through that accounts to a to-do list, and we will work our way through it and act accordingly. It's really going to be up to how things move along. So
Well, I understand we have witnesses,
I know
but,
we won't have a fit schedule for you. We have a to-do list, Mr. Jorde, and we have a lot to do.
but, yeah, but the question is a little different. There's a lot of witnesses, they have to testify, but, I mean, is this place leased for the next 2 months? I mean, I'm just trying to figure out parameters, because right now it's basically every day we just kind of wonder what's happening next, and I'm just looking for some clarification.
We have a weekly digest. Is it up yet? Yep. I think it's already up, so we look forward to seeing your witness availability for next week, and we'll push on. I think Mr. Taylor was
Well,
first.
I make a motion to move the Jorde landowners from number 9 to the very end of the sequence.
Yeah, okay, we can take it under advisement. Mr. Taylor?
Thank you. According to the schedule you put out today, my witnesses are set for next Thursday, but it looks to me like, in all due respect, that maybe that's a little aggressive. I've got 2 witnesses from out of state, and I would hate to, bring them here and then not have them testify at that time. As an alternative, I'm wondering, maybe in order to be more flexible, would it be possible to have them testify virtually?
Mr. Duplinsky, did you have something to say?
Not about this. I'm just waiting to talk about witness availability for next week.
can discuss virtual testimony of witnesses. It's not something we're going to commit to right now, but we can take it under consideration. Appreciate
Okay.
it.
That's fine. It just seemed to me that 6 of Summit's witnesses on Tuesday might be difficult, and we wouldn't get to my witnesses on Thursday, but if I'm committed by the schedule to have them here on Thursday and then not have them testify, that would be unfortunate.
Noted. Thank you. Appreciate it. Mr. Dublinsky.
Yes, and the only thing I would add to that is, yeah, I think that has to be an all or nothing proposition. Either everyone has the option of having witnesses testify remotely or nobody does. But next week, obviously, Mr. Rorie is still on the stand. I just wanted to advise the chair that on Tuesday, we have 2 witnesses that won't be available. One is Mr. McCown, who teaches at Miami University on Mondays and Tuesdays. The other is Jimmy Powell, who will be up in South Dakota. All the rest of our witnesses will be available, and we would proceed with Rorie, finish Micah up, and then Luke, Lumpkin, and Mulbauer, and then we'll have other people here if we, by chance, get through that list.
Thank you. Mr. Whipple, your card's back down.
I was optimistic you would call on me, Your Honor.
I am calling you. Sorry. Thank you.
We're able to offer substantial flexibility. The counties only have 1 out-of-state witness, and similar to Mr. Taylor, just want to be able to identify specifically what day, and so we would be willing, if the other parties in the board are willing to kind of have some intervening party witnesses go here and there based on scheduling more than which party they're for. But 3 of our witnesses are local, and I think the Hardin County witnesses are both local. So since we can get our people here, we're willing to kind of mix and match if that helps things along next week.
Much appreciated. Thank you. Mr. Meyer and then Mr. Long. No?
Nothing, Your Honor.
False alarm. Mr. Long.
We can also offer some flexibility with our witness. I've spoken with him. He could be available Tuesday, probably in the afternoon if needed. We would want some advance notice of that. And then he's scheduled for Wednesday. He could be available Thursday. Beyond that, I'd have to check with him on his any other commitments he has, but we can offer flexibility as well.
Okay. Okay, as we all know, it's unpredictable when we have no idea how many of the questions. The parties, frankly, some of the witnesses have taken far longer than we expected. Some of them have taken far less than expected, so it becomes extremely unpredictable. I appreciate everyone's suggestions, appreciate the flexibility. We will take it under advisement. It is Friday, so I think we need to, there's enough moving pieces here that I think they're great suggestions. So we will be here Tuesday, 8 o'clock. We'll be working through Summit's witnesses, and we can start trying to see if we can put the pieces together so that we're using everybody's time as wisely as we can. So, thank you all. Have a good weekend. Oh, we'll go off the record and wish our court reporter a happy birthday. Thank you.